Hello, my name is Vedant Jain. I am a legal intern with LEXIS and Company. In today's video, we will understand a very important concept of contract law, that is fraud. Fraud can happen in any commercial agreements or in any commercial transaction. Therefore, it is paramount for a party before entering into any kind of agreement or a transaction to know what is fraud, what are the ingredients that constitute frauds, what are the different ways in which fraud can be constituted, and what are the remedies in case a party has been fraudulently deceived by another party. So, fraud can be defined as fraud implies and involves any of the following acts committed by a contracting party or his convenience or his agent with the intention. The important word or the important thing to remember while we're talking about fraud is the intention. Intention of deceiving or inciting another party or his agent to enter into an agreement. The acts can be the suggestion as a fact of that which is not true by one who does not believe it to be true. Second, the active concealment of a fact by one having knowledge or belief of that fact. Third, a promise made without any intention of performing it. Fourth, any other act fitted to deceive. And lastly, any such act or omission as the law specially declares to be fraudulent. Mere silence as to facts likely to affect the willingness of a person to enter into a contract or an agreement is not fraud unless the circumstances of the case is such that regard being had to them, it is the duty of the person keeping silence, or unless his silence in itself is equivalent to speech. For example, suppose A or a person sells by auction a horse to B, which A knows to be of unsound mind. A says nothing to B about horses' unsoundness, and B also asks nothing about the horse's soundness or unsoundness. This is not fraud, and this cannot be a fraud constituted by A. Section 17 of the Indian Contract Act defines and analyzes what is fraud. The main ingredient under Section 17 Clause 1 are: first, there should be a suggestion as to fact; second, the fact should not be true; third, the suggestion should have been made by a person who does not believe it to be true; and fourth, the suggestion should be made with intent either to deceive or to induce the other party to enter into a contract. So, first is the representation. A representation is a statement of fact, past or present, and is distinct from an opinion statement, although a statement of opinion may be considered as a statement of fact in certain circumstances. The fraudulent misrepresentation must be material in order to allow the representative to prevent the agreement, that is, such that it would have affected a reasonable man in choosing whether to enter into an agreement or not. In Lillikutti versus Scrutiny Committee, in the case of Lillikutti versus Scrutiny Committee, a false certificate was obtained in order to take unfair advantage. It was held that fraud vitiates every solemn act. Fraudulent acts are not encouraged by the courts. Any action by the authorities or by the people claiming a right or privilege under the Constitution of India which subverts the constitutional purpose must be treated as a fraud on the Constitution. So, what in case if any false assertion is made without belief in its truth? To prove a case of fraud, it must be proved that the representation made was false to the knowledge of the party making them. The statement must be false in substance and also in fact. Positive knowledge of falsehood is not a criterion. In order to constitute fraud, it is necessary that the statement made by the person concerned with knowledge of its falsehood or without belief in its truth. Even mere ignorance as to the truth of or falsehood of material assertion, which however turns out to be untrue, is deemed equivalent to the knowledge of its untruth, as also where the representative suspected that his statement might be inaccurate or that he neglected to inquire into its accuracy. In the case of Jewson and Sons Limited versus Acros Limited, giving a false impression and inducing a person to act upon it was considered fraud, even if each act taken by itself would be literally true. So, what in case of any reckless statement made by a party into before entering into a contract? So, proof of absence of actual and honest belief is all that is necessary to satisfy the existence of fraud. Whether the representation is made recklessly or deliberately, indifference or recklessness on the part of the representator as to truth or falsity of the representation affords merely an instance of absence of such belief. Statement made without belief in truth would include statement made recklessly. Misrepresentation as to title made by vendors recklessly or with gross negligence cannot escape the charge of fraudulent misrepresentation. Ambiguous statement. What if an ambiguous statement made by a party? When the representer makes an ambiguous statement, the person to whom it is made must prove that he understood that statement in sense that it was in fact false. The representative will be guilty of fraud if he intended the statement to be understood in that sense and not if he honestly believes it to be true. But the person relying on it understands it in a different sense. Once it is held that the representation was fraudulent under this clause, the exception in section 19 is of no avail. And the question whether the person alleging fraud had or had not the means of discovering the truth with ordinary diligence is immaterial. Thank you.